Please get ready for dictation of an extract from a High Court of Delhi judgment, which was delivered on 29th January 2024. It is titled as RECKITT BENCKISER India Private Limited versus Union of India. 5 seconds to go. They also submitted that determination of profiteering can be made at different levels, such as entity level, stock keeping unit level, product level, customer level, etc. Hence, an assessee intending to comply with the law has no way of ensuring whether its methodology is in compliance with Section 171 of the Act 2017 or not. Learned counsel for the petitioners also submitted that the operation of Section 171 of the Act 2017 amounted to price fixing and is therefore violative of Articles 19(1) and 300A of the Constitution. They submitted that according to NAA interpretation of Section 171 of the Act 2017, once any of the events contemplated in Section 171 of the Act 2017 occurs, either there is reduction in tax rate or benefit of input tax credit is availed, then the price of the product must be adjusted to A, the extent of the tax reduced, and or B, the extent of increase in the credit availability. They stated that there is no clarity on adjustments allowed on account of rise either in input costs or in customs duty on import of inputs, supply and demand conditions, and other factors which impact pricing. They submitted that Section 171 of the Act 2017, to the extent it eliminates all factors from consideration in price fixation other than the rate of tax and credit availability, was clearly excessive, disproportionate, and unwarranted. They pointed out that similar anti-profiteering provisions had been introduced in Australia and in Malaysia to ensure that the benefit of reduction of tax rate was passed on to the recipients. They stated that the provisions so introduced prescribed clear policy guidelines before imposing the restrictive conditions. They stated that when Australia implemented the goods and services tax, replacing the erstwhile wholesale sales tax, the Australian Competition and the Consumer Commission was entrusted with the responsibility to oversee pricing responses to the introduction of goods and services tax for a period of 3 years between 1999 and 2002. They stated that Section 71AU of the Trade Practices Act 1974, which prohibited price exploitation in relation to the new tax system, provided that factors such as increase in suppliers' input costs, supply and demand conditions, and other relevant factors shall be taken into consideration while determining price exploitation. They further stated that Section 75AV1 of the aforesaid Act provided that the Commission must formulate detailed guidelines to explain when prices may be regarded to be in contravention of the price exploitation provision. They stated that the Commission had framed detailed guidelines in July 1999, which were later revised in March 2000 after taking inputs from all stakeholders. It was pointed out that the fundamental principle laid down in the aforesaid guidelines was based on a net dollar margin rule. According to them, the said guidelines enumerated all the relevant factors to be taken into consideration for price adjustments and provided for considering the increase in procurement cost and additional costs due to the tax change. They stated that it also allowed averaging the impact of taxes and costs across goods or services under specific circumstances. While referring to the goods and services tax system introduced in Malaysia, they stated that the anti-profiteering measures had been incorporated under the Price Control and Anti-Profiteering Act 2011 to control prices of goods, charges of services, and to prohibit unreasonably high profiteering by suppliers. They stated that making unreasonably high profit was an offense under Section 14 of the said Act. Stop.